Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to discuss the requirements for a battery charge in California. As we saw at the Academy Awards in 2022, in March of 2022, a lot has been made over what is battery in California. Why is someone charged with battery? Why would someone not be charged with battery? So let's break it down. The basic way to basically describe a misdemeanor battery would be a harmful or offensive touching to another. Okay, so someone touches you, you don't want them to touch you, that's a battery in the simplest sense of the word, whether you're injured, whether you're not injured. Any contact, either directly or indirectly causing someone to contact you or something to contact you, could qualify as a battery under California. So first, what are the defenses to battery? Well, one is it wasn't me. I didn't do it, or I wasn't there. The other is it could be, yes, it did happen, but there was consent, right? That person asked me to punch them. That person asked me to smack them. That person asked me to touch them. Also, it could be self-defense, meaning using a reasonable, not excessive amount of force, basically in defense of yourself or of another, or even of property in some instances. So there are certain defenses, even if contact was made, even if it's on camera in front of millions and millions of people, like we saw at the Academy Awards with Will Smith and Chris Rock. So that's the basic outline of misdemeanor battery in California. Now, obviously, felony battery is battery that produces serious bodily injury. So if you actually touch somebody or cause something to touch somebody and they actually get really hurt, well, then that could be a felony battery under Penal Code Section 243D, where you could face up to 4 years in state prison. The worst case you could get on a misdemeanor battery is up to 6 months in jail. So there's a big difference based on the extent of the injury, if any, in play. And then the other issue is, remember we talked about how a harmful or offensive touching could be someone tapping you on the shoulder and you're like, hey, why are you touching me? I never asked you to touch me. Then the issue is prosecutorial discretion or law enforcement's, resources and their willingness to investigate low-level minor batteries that either can or should be worked out between the two individuals. So if someone gets slapped in the face and they actually get really hurt, well, of course, law enforcement's going to get involved. It's a felony, arguably, and they're going to get involved. They're going to investigate it pretty thoroughly. But if it is a misdemeanor battery, usually what you need is the injured party or the aggrieved party, the person who is quote unquote battered, to initiate a police report, to want to press charges, right? Doesn't necessarily mean charges are going to get pressed, but what it does is it at least starts the process. And law enforcement is highly unlikely to initiate their own investigation on a misdemeanor battery for something such as a push or a slap, unless the other party is really driving the force to, hey, I want a report taken, I want this case prosecuted. Then that's something law enforcement should investigate, should turn over to the city attorney or the district attorney, depending on the municipality within the state of California or within a county within the state of California that you're in, and then they investigate it from there. So, I think what we saw going back to the events of March of 2022 with Chris Rock and Will Smith is not all technical crimes or not all crimes caught on camera are prosecuted. Not all crimes caught on camera should be prosecuted. I think the real issue, at least as far as from a criminal defense attorney's perspective, is sort of like this double standard, right? That if I did something like that, I'd be thrown out, I'd be banned, I'd be arrested. But if somebody else does, if a Hollywood elite does, well, it's a different rules, do as I say, not as I do type of stuff. And I get the outrage for that. But from a criminal justice perspective, if everyone got prosecuted for a slap or a push or a harmful or offensive touching, all of us at some point have committed a battery on another person. Whether they're their friend, whether a girlfriend, wife, neighbor, classmate, whoever, all of us in some degree have committed a battery. And few of us have been prosecuted for a battery. So, I think that's really the bigger issue here is I think it's opened up people's eyes to what's a battery, what's not a battery, how things get started with the criminal justice system. A lot of people are justified in their rage or their disgust with how things were handled at the academy. They're disgusted with how things, resorted to violence, albeit low level violence, and I get that. But at the end of the day, the fact that that is not going to lead to a battery, not really surprising. So if you have any questions about battery, assault, anything related to violent felony, violent crime in the state of California, particularly in San Diego County, reach out to my firm, 619-295-3555, 619-295-3555. Again, David Shapiro, San Diego criminal lawyer, where my firm helps good people regain control of their future when charged with a crime. 619-295-3555.